The mainstream media is not talking enough about this, but that doesn't mean that it's not an important thing, and that doesn't mean it's not a real thing. The Phala Phala matter is not going away. In fact, it looks as if more may be coming, more problems for the president. Action SA has announced that they are going to be pursuing some actions in respect to this matter. Action SA leader in parliament, Athol Trollip, has said that the matter needs to be ventilated through the criminal justice process. This is what he had to say.
If you or I were found with $580,000 in our couch, we would have to answer in a court of law, because that is a criminal offense in itself. Where the money came from, that's another matter. Where the money went to, that's another matter. How did they try and follow that money and get it back? That's another matter. There are a whole lot of matters. But the fact of the matter is that there's a contravention of the Foreign Exchange Act in this country, and the president must account for it.
You know, Athol Trollip is not lying when he says that if an ordinary individual were found with a large amount of foreign currency in their house, they would be arrested, they would be charged. And in fact, we've seen people be charged for monies that they could not explain. We've seen this happen. There have been reports about this happening. So I saw people on social media asking, does this mean that they can now keep foreign currency? No. It doesn't mean that. If you see The Undertaker doing a stunt in wrestling, it doesn't mean that you can do that thing at home. That's a professional wrestler. A political figure with such power and influence as the president will always be different from you, even if there's an illusion in the law that we are equal. If the cops find you with $500,000 at the mall, you're going to jail. That's straightforward. There's not going to be any NPA that says anything about your case. Never forget that. So you can't try this at home. The same way that wrestlers tell you, don't try this at home. Don't try anything related to foreign currency at your home. It won't end the same way. And you won't be able to say, but the president. You'll be in jail with Vaseline talking about but the president. And your lover will be telling you, no, it's fine, baby. It's fine. I understand. But when the legal system is not always fair or equal. Don't forget that. So number one, Action SA, their leader is saying that this issue must be taken through the criminal process and that they will be looking into doing just that. The Democratic Alliance has also said that it will ask for a review of the decision not to prosecute. The DA Member of Parliament, Glenis Breitenbach, who's worked with the NPA, has said that the Director of Public Prosecutions must explain the rationale not to prosecute in this matter to Parliament's Justice Committee. She said the following: despite evidence like CCTV footage and mobile phone records, the DPP in Limpopo claims there's no reasonable prospect of a successful prosecution. The NPA owes a full explanation and the public a full explanation, and Advocate Batoi has a constitutional duty to ensure that rule of law is upheld in this critical matter. So now you know, Action SA, they want action. Democratic Alliance, they also want action. Then there's another interesting element, and this is a Kwazam Konto element. Kwazam Konto also has said that they want a slice of this action. They want a piece of the action. There was an interesting exchange in Parliament the other day, and this exchange gives an indication that MK is getting ready for a private prosecution. And the MK action is one that is very, very interesting, because if Arthur Fraser lodged this complaint, and instituted this action with the police as a result of him being part of the Jacob Zuma camp, he may still very well be holding on to lots more evidence. And he's a witness who can be called by the prosecution to testify in this matter. Thus far, he has remained relatively silent, but he is the man who spilt all the tea. And if he is available, this is something that could really be a headache to the president in the context of a public prosecution. So this is what happened when MK asked Shamila Batoyi some questions in the Justice Committee. This is what happened. This was the exchange. Let's watch.
Firstly, I just want, so what I'm going to do through you, Chair, I'm going to, for each of the presentations, I have a question or two throughout. So just for the NDPP, here are my questions. Firstly, this bizarre decision taken by the NPA right now, not to prosecute anyone on the Phala Phala issue. I just want to check from a timing point of view, when can the not prosecute certificate be issued so that the private prosecution can kick in? That's the first question. Secondly, I just want to find out whether in the Phala Phala investigation, who was actually leading the investigation? Was it IDEC or was it the Hawks? Who was actually leading the investigations? Because when the police were talking to Parliament a couple of days ago, General Libya was not saying anything convincing about where is the matter, and he was busy saying a lot of other things except addressing the issue. So I suspect he was not that much involved, but I don't know. But maybe we are here now. Can you just clarify? Was it IDEC or was it Hawks that were leading the investigation? And in that answer, third question is, in that whoever led the investigation, I just want to know, there was a very damning finding by the panel led by no less than a former Chief Justice. And also that panel also had another senior judge. One of the findings there was that the president has a prima facie case to answer in terms of the alleged violation of Section 34, subsection 1 of the PRECA Act. So the question is, did any of the investigators even have a meeting with the president to ask him about this? Was he given an opportunity to explain himself on the such a damning finding by such a highly powered panel led by, as I said, no less than a former Chief Justice? So that's what I just want to find out.
Firstly, on the question with regard to the Phala Phala matter, the decision, the DPP who took the decision is on this platform. I want to say that these are processes, they are processes, also review processes that can be utilized for interested parties who are not dissatisfied with the decision. Honorable Manyi said that he wanted to know when the nolo prosequi certificate can be issued, and to use his words, so that they can kick in a private prosecution. Firstly, there must be a formal request to the DPP for this certificate. And secondly, the words used to kick in a private prosecution would seem to suggest that the decision has already been made to, in fact, institute a private prosecution. And this actually highlights the dangers of private prosecutions. I think it's important, it's good that we have it in our law, but we need to ensure that, like the NPA, that works within a particular legal framework and has a constitutional obligation to ensure that we prosecute without fear, favor, or prejudice, that private prosecutions are not utilized in order to further certain agendas. So the NPA provides that kind of safeguard. With regard to the issue of private prosecutions that were raised with regard to AfriForum, I don't have the figures, but we'll certainly look into the numbers of private prosecutions that have been instituted by AfriForum, where the NPA declined to prosecute and there was a successful conviction. My understanding is that the numbers are, well, I better not say anything about that. Let's look at the figures first before we say anything more about that.
So let's talk about this answer from Advocate Shamila Batoyi, the Director of Public Prosecutions, the National Director of Public Prosecutions. She comes across as defensive. She comes across as if she's defending somebody, as if she has an interest in the matter. Or is it just me? You know, she's not make sure there. She's not make sure. Is it just me, or do you see it too? Why am I saying that? She's very critical of the private prosecution remedy. She's almost complaining about the private prosecution remedy as if there are no controls around the private prosecution remedy in status quo. They are, and that's going to be the topic of discussion as we go forward, just to look at this remedy in more detail, give you the legal framework. But she's coming across as if she doesn't like it, the fact that she cannot close this particular chapter herself and that you have this other avenue that exists. And to me, that's curious. That's curious, and it makes me question her objectivity and whether she's too close to this matter. And it also makes me question whether or not there's another process that needs to be put in place for the appointment of directors of public prosecution, because they are appointed by presidents. And historically, they've proven to be very protective of their presidents. When there was Advocate Sean Abrahams, I think his name was, he was criticized of protecting Jacob Zuma. Now you've got even Zapiro making cartoons where he's critical of all of the decisions that have been made by people who have been appointed by the president in respect to this particular issue. And in as much as we can say with a certain degree of clarity and objectivity, we can say the following. The Minister of Justice, Thembisi Melane, has a conflict of interest as Minister of Justice overseeing the NPA, which is charged with the prosecution and investigation of the matters relating to the VBS saga. She was mayor of a municipality that put money, excuse me, a municipality that put money into the VBS bank. And then she then took loans from an entity that was facilitating that particular deposit and getting commissions from VBS Bank. Political parties have raised that she needs to recluse herself as a result of that because of the conflict of interest that she has as the head of the NPA, which is what the Minister of Justice relatively is, because she oversees the whole NPA. The director is the director, but the minister sits over the director. Now, in the same way that we can see that conflict of interest, we should surely be able to see the same conflict of interest between the president, the Minister of Justice, Minister of Police, as well as the Director of Public Prosecutions, and also, by the way, the Governor of the Reserve Bank. All of these people are appointed at the pleasure of the president. And insofar as some of them want to continue to have another term of office, there's a conflict of interest, which exists when they continue in those jobs. Do you see it? Do you not see it? Right. Let's talk about private prosecution. And I'm going to start with the historical framework here. Right? In primitive societies, and this is the historical framework, in primitive societies, all wrongs were private wrongs, and private vengeance could lawfully be taken against the wrongdoer. It was basically an eye for an eye system, right? And this is the system which led to scholars talking about, law of nature and how we needed to move away from systems where you had these kind of like eye for an eye type of justice systems, right? So over time, because there was this eye for an eye system, it led to disputes between clans. It had situations where there were disproportionate applications of punishment, right, under this so-called law of nature. People would maybe have your cow stolen, you go and kill people because they stole your cows. It was leading to disproportionate applications of justice, inconsistent applications of justice, because rich families, rich clans would not necessarily face consequences. Gradually, as humanity progressed, this was replaced with the idea that there had to be some form of officially enforced system of criminal justice, in terms of which the guilt of an alleged perpetrator could be established, and in terms of which punishment could be meted out without the direct involvement of the victim. So society progressively moved into a system where we had principles of legality, principles of rule of law. You fast forward, you then have the criminal justice system as we understand it, where the state is responsible for the enforcement of criminal law. Basically, human beings give up, right, their right to violence to the state, and then the state has a monopoly on that violence. And part of the application of that violence is imprisonment. Part of the application of that violence is policing its defense, right? And this is what happens in a modern state. How is this codified in a modern state? In South Africa, Section 179.2 of the Constitution gives the prosecuting authority to the state. The state has effectively the authority to institute criminal proceedings and to carry out the necessary functions incidental to the instituting of those criminal proceedings. Section 20 of the National Prosecuting Authority Act gives more detail to these particular authorities. So this is how we get to this particular point. However, there's a caveat. There's a caveat in all of this. When individuals relinquish their right to private vengeance to the state, they did so with a tacit understanding that the state would dutifully prosecute all crimes, or prosecute crimes, if you will. However, the state does not always prosecute for a variety of reasons. Prosecution is not compulsory in every instance, and prosecuting officials are vested with discretion to prosecute or not to prosecute. So because there's this discretion and because prosecution is not always compulsory, there is a provision provided to individuals. The decision to not prosecute may aggrieve an individual who happens to be a victim of a crime and who has been deprived of his ancient right to self-help and self-prosecute and get vengeance. So the pathway that has been provided by many states around the world is to have systems of private prosecution. Private prosecution is generally described as a safety valve in the machinery of the law, and it demonstrates the value of citizen and victim participation in the criminal justice system. There are other instances where similar principles are applied. For instance, private persons can assist in an arrest when called upon to do so by a police officer. Private persons not personally involved in a case can also be called upon and agree to sit as assessors in criminal trials. And you can look at Section 93 of the Magistrate Courts Act for that authority and support. Right. So in the South African system, there are two types of private prosecution, right, which are provided for by the Criminal Procedure Act. Number one is private prosecution by an individual on the basis of a certificate, which is known as the nolle prosequi. And this is provided for in Section 7 of the Criminal Procedure Act. And then there's also private prosecution under a statutory right, which is done by groups, etc. And this is in Section 8. I'm not going to discuss that here, but I'm going to look at private prosecution by an individual on the basis of a certificate. Here are the key details that you need to know about this private prosecution. You need to know that a private prosecution must be instituted and conducted in the name of the private prosecutor. So if you're going to do this, it must be instituted and done in the name of this private prosecutor. All processes must be issued in the name and at the expense of the private prosecutor. A private prosecution shall proceed in the same manner as if it were a prosecution at the instance of the state. An accused person still enjoys all the procedural rights which would have been available to him had he been prosecuted by the state. So how do you get this locus standi to be a private prosecutor? Because you can't just be any Jack and Jill who went down the hill and then go to a court and say, I'm here to privately prosecute. You need to have the authority to appear before that particular court, which is known as locus standi. So, in any case in which a director of public prosecutions has declined to prosecute for an alleged offense, the following persons may, subject to certain other procedural requirements, either in person or through a legal representative, institute and conduct a prosecution in respect of such offense in any court which is competent to try that offense. Who are those persons? Number one, any private person who proves some substantial and peculiar interest in the issue of the trial arising out of some injury which he individually suffered in consequence of the said offense. So basically what they're saying is any private person who has a substantial and peculiar interest in the trial arising out of some injury which he individually suffered in consequence of the said offense. So for the Phala Phala matter, this is interesting because some of the accusations pertain to tax evasion. And if there is tax evasion, basically every citizen can say that they have an interest and that they have suffered a loss, because if there was an evasion of tax because of money that was used to buy and sell a particular thing, and that money was not then declared to SARS and then paid off as a tax, whatever obligation was supposed to be paid off as tax, then many people can say that they actually lost out and they have injury. So you've seen a lot of times AfriForum being able to go to courts and institute private prosecutions on behalf of other parties, and they've been able to successfully actually get locus standi. So whether or not MK will be able to get locus standi is something that is likely to happen. But even if they don't get it, remember Arthur Fraser is the person who opened the case in the first instance. He can still institute a private prosecution in his own name. He can still do that. And he can then retain the legal assistance of legal representatives, etc. So the pathway to level 1 is one that is relatively open in this case. The second group of people who can get locus standi, a husband, if the said offense was committed in respect of his wife. 3, the wife or child, if there is no wife or child, any of the next of kin of the deceased person, if the death of such a person is alleged to have been caused by the said offense. So husband can go for his wife, a wife can go for the husband, child can go for the wife and or father, and if there's no wife or child, next of kin can go and prosecute a matter if that matter is supposed to have been the reason for the death. So that's 1, 2, and 3. Any private person with an interest, husband, wife, child, next of kin. Also, number 4, the legal guardian or curator of a minor or lunatic if the said offense is committed against the person that they are custodians of. So these are the people who can approach. But no person can just go. You need the certificate of nolle prosequi. No private prosecutor wishing to proceed in terms of Section 7 can obtain the process of any court for summoning any person to answer any charge unless such a private prosecutor produces the nolle prosequi to the officer authorized by law to begin such a process. So you can't just start, you have to get the certificate. This is a certificate that is signed by the director of public prosecutions, which confirms first that he has examined the statements and or affidavits on which the charge is based, and secondly that he declines to prosecute. Effectively, there's no certificate now, but by issuing the statement which was issued by the director of public prosecutions in Limpopo, they have basically committed to the material details of this. And so it shouldn't be very difficult for somebody to say, excuse me, and apologies for the burp. It shouldn't be very difficult for somebody to then be able to say, right, the NPA has said they're not prosecuting, give us the certificate. And even within 24 hours, I don't think that they would have a reason now to say, no, we're not going to do it. Right? So the director of public prosecutions must, at the request of the person intending to prosecute, grant the certificate in every case he has declined to prosecute. It's not optional. In terms of Section 7.2c, a certificate shall lapse unless the proceedings in respect of the offense are instituted by the issue of the required process. You're also required to deposit security with the court in whose jurisdiction the offense was committed. Sometimes that amount of money has been quite a significant amount of money, but from the textbook, it seems like 2,500 is how much you need in a magistrate court. A director of public prosecutions still can come back and reclaim the case. This is how it happens. A director of public prosecutions may, in respect of any private prosecutions, apply by motion to the court before which the private prosecution is pending to stop all further proceedings in the case in order that a prosecution for the offense in question may be instituted or continued at the instance of the state. So even as you are moving on with a private prosecution, the director of public prosecutions can still jump back on the wagon. So that's just an interesting side note to this whole thing. Some final comments on this matter. I actually don't think that the president wants a private prosecution. I don't think that he does. This would entail him being on the stand as a witness, being cross-examined by Advocate Limpopo and several others if this case has more than one private prosecutor, right? You could end up with a situation where you know, you've got advocate Limpopo, you've got another advocate grilling the president in a way that he wasn't grilled at the State Capture Commission, you know, and him having to fully explain a variety of unanswered questions about this money and his family business dealings in front of the whole country, in a space where Zondo is not gonna be able to help him and cut the cross-examiners and, you know, redirect the questions, because the questions will be fully facing him 1v1. I don't think that he would want it, because I think it would expose a lot. You know, the president declares his business dealings, etc., to Parliament, but the law doesn't require you to declare anything that you are doing with other private individuals. So he's only declared, I think the last declaration was for 76 million rands, but he's a billionaire, right? And there are many businesses that the Tivashe Trust and other entities are still involved in that he doesn't declare. And for a very long time, everybody thought that the president everything is being done in a blind trust. But clearly, some of the stuff is being done in a blind trust, but with one eye open, because he was aware of the issues that were taking place at the Phala Phala farm. So in that respect, he was aware of business dealings that were being made by a company that he has ownership of and he's the director of, right? So I don't think that he wants these types of questions to be asked to him in a private prosecution, because the answers really, people have been quite skeptical of everything that he has said thus far. Even the former Chief Justice was like, the story is not adding up. Because the president gave a version to the former Chief Justice. And the former Chief Justice was like, you know, I was born at night, but I wasn't born last night. This ain't right. That's what he said, not in those words. You know, I'm kidding around. I'm paraphrasing. But he was very skeptical of the president's version. And it wasn't just him. It was another judge and a trained advocate who said, listen, we've been dealing with criminal law for a long time. We're not happy. We think that there's a prima facie case. You need to go to Parliament to explain further. And that explanation may still be one that could be coming. But we know the president didn't want to explain to Parliament, which is why, you know, we saw Fikile Mbalula moving fast to block any vote for the impeachment ad hoc committee to be set up. We saw that, right? So I think he has concerns here. As things stand right now, it seems that the NPA will delay the process. Shamila Batoi's comments and remarks seem to me that if there's a request sent for that Nole Prosecute certificate, it's not going to come overnight. She seems like she wants to do more stuff internally, which is why she said, no, we can review the decision, etc., etc. Because if you say you're reviewing the decision, you can sit for another year. In fact, the whole delay thing is something that to me has been something I've found to be frustrating, because the prosecution, the NPA sat on this for a while. This case was lodged in 2022, in June of 2022. We are now in October of 2024. If they realize that they don't have evidence, surely they could have said that within 3 months. It didn't need 2 years, right? And maybe the stuff that they try to do, evidence that they try to get, but it looks to me the Reserve Bank took its time, the Public Protector took her time. The only group of people which moved fast were the group of people who were not appointed by the president, who were appointed by Parliament, and that was the Section 89 independent panel. They were done in the constitutionally required time. They asked for one extension. They were supposed to submit, I think, at the beginning of November. They submitted at the end of November. They were done, right? Everyone else has taken time. And, that's something that I have questions about. But as things stand, it looks as if there will be some more delays here. I think NPA will delay. And I think part of what supports this reasoning is that the decision not to prosecute was announced by the Limpopo Director of Public Prosecutions and not the National Director of Public Prosecutions. And I think this is to give some room to say, no, I'm the head. I still need to apply my mind. I still need to think, right? The challenge, though, that the NDPP has, the National Director of Public Prosecutions, is that you can only buy time for so long, right? This issue is already, I mean, 2024 is almost over, but the end of term is 2029. That's still far. There's still 4 years and 8 months or so to that time, if you think about it. So even if you are trying to find a way, it's still going to take a long time to prevent all of the legal steps that can be taken, and I don't think they'll be successful. If this starts heating up even in 2 years' time, that will be the same time as the conference, ANC elective conference. If it gets to the point where it heats up in 2028, then the new leadership of the ANC can request that President Cyril Ramaphosa step down. We need to remember Thabo Mbeki didn't finish his term. Jacob Zuma did not finish his term. The question then is, will Phala Phala be the reason why Cyril Ramaphosa does not finish his term? I mean, he was ready to resign when this story first broke in 2022. Will the NPA be able to buy him enough time till 2029? Or will he resign in 2027 or early in 2028? What do you think? Let's have a conversation. Till the next one.